All right, so this video covers the importance of corporate compliance programs for some of the areas dealing with export regulations, corruption, bribery, RICO violations, etc., and as well as examples of some cases that have been prosecuted. So we really cannot emphasize enough the importance of corporate compliance programs because these, among other things, help keep the company out of trouble. They tell employees or help employees understand conduct that they should not engage in, as well as conduct which is permissible to engage in. And they're just, when many employees who simply don't know what they can do and what they cannot do, or what they should do or what they should not do. So these kinds of programs, training programs, are very important. One, to just help employees understand proper conduct or prohibited conduct. But number two, if the company does get in trouble because of some activity by an employee, they can help mitigate and protect the company from more adverse charges, because they've made a good faith effort to, to mitigate or prevent the illegal or improper conduct. So, so they're very important, and they should explain, issues for employees under FCPA, for example. When can you make a payment, and when can you not make a payment, and when should you contact the legal department? Like if you think you're going to make a grease payment, under the grease exception, the facilitating payments exception, you generally should call the legal department and get an opinion from them. When should you contact a compliance officer? If it's not the legal department, a compliance officer. Just as a side, I might note that complying with the internal compliance controls of Sarbanes-Oxley, which requires a number of signatures coming up through the administrative management group, verifying that the numbers in these reports are full, complete, and accurate, itself is not a defense for FCPA violations. That argument has been tried, and so it doesn't work. But so we start with a corporate policy that is documented, and the corporate culture of the company is so important. So you start with a website, you start with a manual, but a website or a manual by itself is not a corporate policy. A corporate policy is something that is living and that is communicated to employees on a regular basis. So they are reminded that the company has this policy, and it's not just something that sits passively in a notebook or on a website that people never visit. New employees will routinely go through training, which could simply be watching a 1-hour video, for example, on FCPA requirements, and then answering 10 multiple choice questions. But certainly training for new employees, and then regular reminder training for current employees. Maybe every 2 years, have them sit through another 30-minute or 60-minute video and document it. Because then if that employee engages in some improper conduct, then the company has some record that it's making a good faith effort to prevent this type of conduct. So supervisors need to support the policy. They should not be minimizing the policy as just another administrative hurdle. We're here to complete projects and make money. I mean, the policy is important. Supervisors need to support it. And oftentimes you want some way for employees to report violations anonymously. It'd be better for them to report it internally to the company, and the company to take action internally, rather than have them go calling Department of Justice or Securities Exchange Commission and report it, and then have U.S. Marshals show up your door unannounced and be shut down. So the point here is you can start with a written policy on a website or a manual, but it needs to be active, and you need to push it down, and management needs to support it. if you do have a means for reporting inconsistencies anonymously, then many times companies will start an internal investigation, even if justice or SEC has been notified. Companies will oftentimes be required to conduct and pay for an internal investigation by hiring an independent firm, such as an accounting firm. So, you know, this is common. Department of Justice by itself, or SEC, doesn't have the manpower to conduct these internal investigations. So it's quite common to have it handled this way. Let's look at the prosecution of a couple of cases. Here's one involving importation of rice, Texas company exporting rice to Haiti, and they're paying the customs guy for understating the amount of rice on the bill of lading, so they don't have to pay as much tariff. So that's a violation right there on the bill of lading. I might add that I do want to mention the SEC Whistleblower program, which was part of the Dodd-Frank law of 2010. It's turned out to be a very successful program for the Securities Exchange Commission that oversees it. Final rules took effect 2012, and in the first year alone, they got over 3,000 tips alleging fraud, corporate disclosures, financials, etc. So that is a very active program, and it has been very successful. There is a possible issue here. Many times companies will have employees sign secrecy agreements, confidentiality agreements. We've talked about these to some extent, NDAs, when businesses are negotiating. But employees will often sign confidentiality agreements, and sometimes they have, you may find they have gag provisions that prevent an employee from reporting improper conduct. So the question is whether these gag provisions conflict with the statutory obligations and the policies under the Whistleblower Act. This came up in Barco versus Halliburton, involving Kellogg, Root and Brown, a big consulting company doing work in Iraq, and some laundry services provided to the military. And Barco alleged that the company was inflating the cost of the laundry services. So nothing very definitive on it as far as we know at this point, but it is just something to keep your eye on. When you're engaging in international business, some of the things you want to do to minimize FCPA violations: avoid payments in cash. If you're using an intermediary, a consulting firm, don't just give them gobs of cash and say do whatever you want. Require them to account for their transactions and have them written with checks or bank transactions. Prohibit government employees or political officials from holding management firms in the company. We've seen this in Ukraine, where a Ukrainian government official had an energy consulting firm. So hire his energy consulting firm, and he will help with the permitting process through the government. I mean, this is clearly a conflict of interest and involves some improper conduct. You may have to retain local attorneys to give advice about violations. If your consulting firm receives complaints from employees, ask that you be given notice about it. And require the consulting firm to be aware of the FCPA and money laundering laws. And you want, whoever you're auditing or whoever you're hiring, you want audit rights to go in and see their books on reasonable notice, and provide they do not keep two sets of books. The Siemens case is certainly a famous case involving FCPA, and came out of investigations and monitoring of money transfers after the 9/11 attacks in New York City and the Pentagon by Al-Qaeda. And it wasn't just the United States conducting investigations. There were many countries watching the flow of money, and the Swiss were one of those. And in the spring of 2003, they noticed, or these auditors for a Liechtenstein bank they were looking for terrorist funding, and they noticed an unusual amount of money transfers to a offshore company called the Martha Overseas Corporation. And so they quietly investigated this and watched to see what was going on. Again, their initial motive was looking for money used to fund terrorist activities, which of course is a very hot issue today with ISIS. And they found that it was controlled by a top executive in Greece who worked for the Siemens Corporation, a huge German construction and technology company. So they found millions of euros being deposited, and they quietly investigated for 3 years. And then in 2006, 3 years later, the German police raided the Siemens offices and locked everything down and arrested people and prosecuted people. And in this trial, 2008, here's a former manager testifies that paying bribes was an open secret in the telecom subsidiary where he worked. They would use these yellow sticky post-it notes to write instructions so they could be easily torn off and discarded, and there wouldn't be any incriminating evidence. He testified that the CFO, the chief financial officer, the top finance guy in Siemens knew about the bribes, and that they would pay non-existent consultants, so fake consultants, fake employees, and channel money in slush funds. They identified over $2.1 billion in suspicious activities. And so, of course, once the Germans start these kinds of investigations, the U.S. and other countries start their investigations. FBI states they found middlemen posing as consultants who delivered suitcases filled with cash to bribe foreign officials. And SEC report $1.4 billion was paid to officials in Asia, Africa, Europe. I mean, this was a corporate culture in the company of just bribery and corruption. It was a standard for doing business. And the SEC itself brought charges against 7 former Siemens executives. And these are you can actually look at the complaints and see what they were engaged in. So it's a big case. It actually still continues to go on today. Hewlett-Packard in Russia. Russian German authorities investigate HP. They raid their Moscow offices. They find they were paying millions to get contracts. And money was used to pay fake invoices to shell companies that were set up in Latvia, Lithuania, Switzerland, Belize, just all over the world. Again, just a conduct of corruption in order to get contracts. They created a fund through which money was routed to Russia via a German subsidiary and a network of shell companies and accounts from places as far away as Wyoming and New Zealand. So, obviously, very serious efforts to hide the bribes and the money, and yet they still found it. And we've said before, by definition, a bribe is not open, it's hidden, and will always be a violation of the books and records provision. So here's a settlement. In the settlement agreement, this is a public document, the SEC order, page 2. A subsidiary, HP Russia, made payments through HP Russia's agents to Russian government officials to obtain multi-million-dollar contracts. Were made through shell companies in Poland. They had a Polish subsidiary provide gifts and cash bribes. There was a Mexican subsidiary, made improper payments to third parties. The details are just amazing at the blatant conduct. So, and you can look at this and see what this Walmart delivering envelopes of cash to mayors, city council members, and urban planners to get permits to build Walmarts in Mexico. And it was invoiced in code and then purified in accounting records and legal fees. So again, they're hiding the payments. Mexico, China, India, Brazil, massive corruption and improper conduct. And of course, when they discover this, they've got to do it immediately, do an 8K filing, notify the public. It affects the stock price, and which usually plummets. And it's a serious issue for the company because they end up paying fines. And the fines come out of what? They come out of earnings and profits, which is the same account used to pay dividends, which means the shareholders are basically paying. Mercedes, Dalmart, 51 transactions here, business in 22 countries in Russia, China, Vietnam, Nigeria, Bosnia, Croatia, Latvia, Hungary. A sale of 6,300 commercial vehicles, 500 passenger cars, and using sham intermediaries and consultants to funnel the funds. So this is what we're talking about, the intermediary provisions of the FCPA. This is how you get them. Drug charges, against the drug companies. Subsidiaries made improper payments to foreign officials to win millions of dollars of business in Russia, Brazil, China, and Poland. Used offshore marketing agreements. So, you can take a look at this. Here, sales reps encouraged by supervisors to submit false expense reports. The money was used as gifts to government-employed doctors who were recommended to buy these drugs. It's just blatant. They get caught. They pay huge fines. And here's a policy statement. Well, actually, this is not it, but Microsoft being investigated. If you're from Saudi Arabia or familiar with Saudi Arabia, the Al-Yamama case, a famous case in which supposedly bribes were paid to the British government, were paid to Saudi Arabia princes and officials, government officials, to buy British fighters. There's a whole video about this on Black Money, where it was reported to the British Serious Fraud Office that oversees fraud, and how some people feel it was somewhat whitewashed. Prince Bandar was mentioned in some of these transactions. Some of the money used to rehab his palace in Saudi Arabia. He's been here in the Washington area for a long time. You see him some of the cocktail parties. But the charges were the Serious Fraud Office kind of whitewashed it, but then it was picked up by the Department of Justice, who investigated BAE, which has numerous offices here in the Washington, Reston, Northern Virginia area, and they pled guilty. And here you can see the Justice Department used these documents. They're public documents. There are a number of cases. There's actually a website. You can go on the website and see these current cases reported by the SEC. But this point I want to mention is very important. This notice came out just September 9th of this year, 2015, where they announced, they had been going after the companies and secondarily the individuals, but now they've announced a new policy regarding liability and prosecution of individuals who perpetrated the misconduct, both civil and criminal, It's designed to ensure that all attorneys across the department are consistent, best efforts to hold account the individuals. The shift is to hold the individuals responsible and not make them secondary to the investigations. One of the most effective ways to combat corporate misconduct is by seeking accountability for the individuals who are perpetrating the conduct. It applies to civil and corporate. The guidance reflects 6 steps to strengthen our pursuit of individual corporate wrongdoing. In order to qualify for any corporate credit, cooperation credit, the corporate entity must provide to the department all relevant facts relating to the individuals responsible for the conduct. The investigation should focus on the individuals from the beginning, not at the end, which is what they had been doing. The attorneys handling investigations should be in routine communication with each other so they can share the information. So, again, the shift now is to get these individuals, should not resolve matters with a corporation without a clear plan to resolve the individual cases. They had been resolving with the corporate entity and then going after the individuals. Now, they want the individuals. And so there are huge penalties to be paid. The cost of the violations are huge. But then remember, the cost of the investigations, the cost of legal fees are phenomenal. And European Union has their own anti-fraud office, and you can look at these cases as to what they are doing. They're very active. Here's a shipment of sugar to Croatia through Kaliningrad in Russia. And how they were engaging in some bribery. Chinese textile imports claiming to be from Bangladesh. Snoop Dogg, I caught Snoop Dogg on not money laundering, but carrying more cash than he should have been without declaring it. So these are serious issues. Corporate compliance programs will help mitigate employees engaging in this conduct and certainly be helpful to companies if wrongdoing is discovered. So that concludes my presentation on these issues.